Hi everybody, and welcome back to Bowdie Shorts, making law make sense in 15 minutes or less. In the last episode, we looked at duty of care and asked the first question in any negligence claim. Did the defendant owe the claimant a duty of care? Today, we're moving on to the second question. Did the defendant breach that duty? And this is often where negligence claims are won or lost. Just because somebody owed a duty of care does not automatically mean they are liable. The claimant must show that the defendant fell below the standard of care required by law. By the end of this video, you'll understand the reasonable person test, the special standards that apply to professionals, learners, and children, and the factors courts use when deciding whether someone has acted reasonably, and how breach of duty is actually proven. Let's get into it. So what does breach of duty mean? Well, breach of duty is really a question of fault. Once a duty of care has been established, the court asks, did the defendant behave as a reasonable person would have behaved in the same circumstances? If the answer is yes, there is no breach. If the answer is no, there probably is. So take a simple road traffic accident. A driver clearly owes a duty of care to other road users, and that's not normally in any way controversial. But that does not tell us who, if anyone, is liable. We still need to know whether either driver did something unreasonable. Were they speeding? Were they distracted? Did they fail to look before pulling out? Or did the accident occur despite both drivers acting carefully? The key point is negligence is not about whether an accident happened. Accidents happen all the time. Negligence is about whether somebody failed to take reasonable care. When analysing breach, the court follows two stages. First, it identifies the relevant standard of care. Secondly, it compares the defendant's actual conduct against that standard. The reasonable person test is our starting point, and the law does not actually expect perfection. It does not require defendants to eliminate every conceivable risk. Instead, it expects people to behave as a reasonable person would behave, and this is an objective test. And that's an important phrase for SQE purposes. Objective means the court is not overly interested in what this particular defendant thought. Instead, it asks, what would a reasonable person have done? So imagine a defendant says, I didn't think it was dangerous. That alone will not help them. The real question is whether a reasonable person would have recognized the danger. Similarly, a defendant cannot generally escape liability by saying, I tried my best. The issue is not effort. The issue is whether the required standard was met. And one of the easiest mistakes students make is focusing too much on the defendant's personal beliefs. Remember, the defendant is measured against an external standard, not their own opinion of how careful they were being. Now let's move on to look at special standards. So although the reasonable person is the starting point, the law recognizes that some situations require a modification to that reasonable person test. And the question becomes, what would a reasonable person in the defendant's position have done? And there are three areas that need to be tested. The first is skilled defendants, and this is where somebody claims to possess a professional or specialist skill, and they are judged according to that skill. A doctor is not judged against the standards of an ordinary member of the public. A doctor is judged against the standards of a reasonably competent doctor. The same principle applies to solicitors, accountants, architects, surveyors, and other professionals. And this comes from the principle established in the case of Bolam. Now, for SQE purposes, you don't need to memorize endless facts about Bolam. What matters is the principle. A professional is expected to meet the standards of their profession. So if their conduct would be regarded as acceptable by a responsible body of professional opinion, they will generally avoid liability. However, the court does have the final say, and this is where the case of Bolitho becomes important. A defendant cannot simply point to one professional who agrees with them and automatically escape liability. The professional opinion being relied upon must be capable of logical analysis. So the big takeaway here is professionals are judged as professionals. The next group are inexperienced defendants, and students often assume that inexperienced defendants receive a lower standard of care. Generally speaking, they do not. The leading example is a learner driver, the case of Nettleship and Weston. And a learner driver is judged according to the standard of the reasonably competent driver, not the reasonably competent learner driver. And the logic for this is straightforward. Other road users need protection. The standard of driving that the public can expect should not vary depending upon who happens to be behind the wheel. The same approach applies in professional settings. A junior doctor is expected to meet the standards expected of someone carrying out that role. Patients cannot receive a lower standard of care simply because the doctor happens to be inexperienced. The key SQE exam point here is that the standard usually follows the task being performed, not the individual defendant's experience. Final group are children. Children are also different. A child defendant is judged according to the standards of a reasonable child of the same age. And the law recognizes that children do not perceive risk in the same way as adults. A court therefore asks, would a reasonable child of this age have appreciated the risk? Now notice the contrast there. A learner driver receives no reduction in the standard because of inexperience. A child, on the other hand, receives an age-adjusted standard because children are considered fundamentally different from adults, and that distinction is definitely worth remembering. So how do courts decide whether there has been a breach? Well, once the court knows the standard it wishes to apply, it then decides whether the defendant's conduct fell below that standard. And when doing this, courts essentially balance two things: the risk created by the defendant's activity and the precautions the defendant could reasonably have taken. Now, several factors help the court make that decision. The first one is the magnitude or size of the risk. And courts ask, how likely was harm to occur and how serious would that harm have been? So the more likely the harm, the more precautions are expected. Equally, the more serious the possible consequences, the greater the level of care required. So imagine two situations. In the first, there is a 1 in a million chance of a minor injury. In the second, there is a significant chance of catastrophic injury. You would expect different levels of precaution in each of those situations, and the law reaches exactly the same conclusion. So one useful principle here is that defendants are required to guard against reasonable probabilities, not fantastic possibilities. The law does not demand paranoia, it demands reasonableness. However, where the possible consequences are especially severe, courts will expect defendants to take additional precautions. If the likely harm could be blindness, death, or life-changing injury, the standard of care will rise significantly. The next thing to look at is cost and practicality of precautions. And the question here is, what could reasonably have been done to reduce the risk? And the law expects reasonable precautions, not perfect safety. So if a risk can be substantially reduced through simple and inexpensive measures, a defendant may be negligent if they actually fail to take those steps. On the other hand, if the only way to remove a small risk is through enormous cost or disruption, the court may decide that doing nothing was reasonable. The key point is proportionality. The greater the risk, the more the defendant is expected to do. The less of the risk, the smaller the risk, the more likely it is that limited precautions will be sufficient. Now, one thing defendants cannot usually rely upon is lack of money. Simply arguing we couldn't afford to make it safer is rarely, if ever, going to be a successful defense. The court will also then look at why the defendant was acting. What was the defendant's purpose? And not all risks are taken for the same reason. Sometimes a risk is taken for commercial profit. Sometimes it's taken to save life or prevent serious injury. And the law recognizes that socially valuable activities may justify taking greater risk. So think of emergency services responding to a life-threatening situation. The courts may be willing to accept a higher level of risk where the objective is rescuing somebody or protecting the public. That does not mean emergency services, though, can act recklessly. It simply means that context matters. So always ask, what was the defendant trying to achieve? Another factor is common practice, and a defendant who follows accepted industry or professional practice is in a stronger position than a defendant who ignores it. However, common practice is not an automatic defense. An entire industry can adopt poor safety habits. Now, if a common practice is in itself unsafe, the court can still find negligence. So think of common practice as a persuasive evidence rather than a guaranteed shield. Finally, courts consider the state of knowledge known at the time, and defendants are not judged with hindsight, and this point is extremely important. When analysing breach, ask yourself, what risks would a reasonable person have been aware of at that particular time? If a danger was genuinely unknown, a defendant is unlikely to be criticised for failing to guard against it. The law judges people according to the knowledge available when they acted, not information discovered years later. A couple of things on proving breach. The burden of proving breach rests with the claimant. The standard of proof is the normal civil standard, namely the balance of probabilities. In simple terms, the claimant must show that it was more likely than not that the defendant breached their duty. And most commonly, this is done through witness evidence. Sometimes expert evidence is required, particularly where professional standards are involved. And you may also come across the phrase res ipsa loquitur, which means the thing speaks for itself. This applies in a small number of cases where the circumstances of the accident strongly suggest negligence, even though the claimant cannot identify the precise mistake that was made. If certain conditions are met, the court may draw an inference of negligence and require the defendant to provide an explanation. Finally, a relevant criminal conviction may assist the claimant. For example, a conviction for careless driving may provide powerful evidence of a later negligence action arising from the same incident. So what's Bowdie's bottom line? Well, when you're faced with a negligence question, don't start by hunting for case names. Start by asking 3 questions. What is the relevant standard of care? What risks existed? Would a reasonable person have done more in those circumstances? If the answer to that last question is yes, there is likely to be a breach. Remember, the standard is usually objective. Professionals are judged as professionals. Learners generally get no discount for inexperience. Children are judged according to their age. Higher risks require greater precautions, and courts always focus on what is reasonable in the circumstances. If you can apply those principles and apply them to the facts in front of you, you'll be in a strong position to tackle SQE questions on breach of duty. Thanks for watching this Bowdie Shorts. In the next episode, we'll move on to causation and examine how the courts decide whether the defendant's breach actually caused the claimant's loss.